I'm going to go grab myself a fill up on water too.
All right, everybody, welcome to the Creative Finance Collective. I'm Andy Fowler, and we're just getting a few folks logging on here to be a part of the collective. If you're joining us for the first time, what is the Creative Finance Collective? It's an opportunity for lawyers and other professionals that are involved in the creative finance space who understand or are working to better understand creative finance to get together and talk about what they're doing, what they're seeing, uh, all that's going on. And then we take the hour to answer any questions that you have as the listener. So if you have questions, if you're watching the collective here and you're thinking about creative finance or you got a creative finance problem or whatever it is, go ahead and post it in the chat. We'd be happy to address the questions as best we can. Um, right now we got Drew and Sean, and it looks like Alan Seshker's looking to get on, but um, it's having some video issues. Alan, can you hear us? Is your audio coming through? Okay, no audio yet. He's still working on it. Sean, how's it been?
It's been all right. Been good. Yeah. So it just seems like a couple hours ago we were doing this on the in-rim. So
yeah. Just talking to Drew. Drew, you were just mentioning you're seeing a ton of probate cases come through recently, or given the economy, you were dealing with probate issues. What were your thoughts?
So I have a couple of investors, one in particular who specializes in probate. And so he's great, right? And I mean, he knows exactly how to hold their hand, and he doesn't even bring me deals basically until letters are issued, right? Or, assuming that we don't need to go through probate due to the amount of time that's lapsed. He won't bring it until we've identified all of the heirs, and basically the file is ready to close like a normal file. But it's everyone else in the market. It's all of the other sort of mid-market wholesalers and flippers that don't understand probate, that they'll get under contract and they'll bring me a file. And I think one of them, we've been going on this for almost 12 months. And I mean, from my perspective as a closing attorney, that's just a really long time, right? To have to kind of shepherd and check up on a file. And then a lot of them are learning a really hard lesson, is that the person that signed your contract, if they don't have, if they're not authorized by the court to sign on behalf of the deceased, and then once they start probate and they start getting all those letters in the mail for offers for their home, well, that's how we keep Brian fed, right? Is it winds up in litigation.
So let's talk, Drew. What do you do if you have a client come to you, they give you a contract, you figure out, oh shoot, a probate's required. You go and tell them, hey, go figure the probate out, give me some letters, and then you get letters. Do you then have the parties re-execute a contract at that point so that you've basically reaffirmed the prior contract, but had it dated and properly done after the letters? Or can you go on the old contract as long as whoever was appointed was the person that signed the old contract?
So I actually just had this happen about 2 weeks ago, and we had them ratify it because both the husband and the wife wound up as co-executors of their son's estate, right? And only the wife had initially signed. And so due to the change in the executors from her signing to being both her and the husband, we had them execute a ratification, right? And move forward and are moving forward. That file still hasn't closed. Generally, if we're dealing with the same person, right, so long as they, in their capacity as executor or administrator, whatever have you, so long as they're signing all of our closing documents, they're signing our settlement statement, agreeing to the amount of funds for the estate, and obviously they're authorized through either letters testamentary or through the will, letters testamentary, or through the letters of administration with power to sell, then I don't require them to go back and redo it. Because if they're signing my closing paperwork, then in their appropriate capacity, they're authorizing the transaction on the terms therein. And right. Like I was saying, I'm seeing a lot more of probate, and it's from a lot more of my clients who don't generally ever touch it. And It's a learning curve for them.
Yeah.
They're like, why can't
Well,
we
guys,
close?
I'll tell you one of the funny things that I see so often out there is the sheer idiocy that people have no knowledge of probate whatsoever. The first thing that, you run across into the general population is that everybody thinks that a will has to be probated. And of course, that's not necessarily true, at least not here in Texas. The next thing that I know I see a huge amount of this, I'll bet Alan sees a lot of this, is where people think that just because there's a will and they were named as an executor in the will, they're signing the contracts, everything else as if they're the executor. And of course, the seller is doing this with another investor who has no knowledge of probate at all as well. And they think that because there is a will and the person is named as the executor, they're getting a good contract, which of course we all know the answer is yeah, not so much. And then of course, no one seems to understand that there's a statute of limitations on filing that will for probate within 4 years from the death of the testator. And we get wills that come in here 6 years old, 8 years old, 20 years old, and they think they're still going to utilize that, and they simply don't understand. So you got to go through the whole learning curve along the way. And of course, none of these people want to go through a dependent administration, which wouldn't help anyway. And so oftentimes we're left at that point going through, of course, heirship affidavits, which, at least from my perspective in the real estate side, is the easiest way to navigate that and to accomplish the final sale of that property.
Well, are there dollar amount limits for the heirship affidavits and like waiting periods for that in Texas? Because that's what we have in Arizona. We can do heirship affidavits as long as the person's been deceased for over 6 months, and the value of the property, I think, is, or the equity, their share of the equity is less than 100,000. What are the limitations in Texas on heirship affidavits?
I don't know of any limitation to date on that. I don't know if Alan knows something I don't know about that or not.
I don't know of any dollar limitation. Underwriters are the ones that say 6 months. I think they're the ones that say. I don't know if there's a statute on that or not.
Yeah, well, I agree. Well, Alan, I agree. The underwriters, if you're getting title, are always going to dictate that. So we run it past them in that regard. And, are they willing to let it go or not go? I think that just depends in that scenario. I don't think there is a statute per se that says you can only use an heirship affidavit within so many months of death. But I think underwriters want to see a certain time frame out there just to see if there is a will that might exist that they finally find through whatever mechanism the heirs are trying to do to find it out there. But gosh, I will tell you that in 94% of our transactions that we deal with that have some probate involved, there is no will. And of course, mom, who died last, and guys, why is that? Why is it we guys always have to die first? That is not fair. I think it's the women that drive us crazy. The cheap seats over here by me are, hackling me right now. But, what I find so interesting out there is when we come across probate scenarios from the investor scenario, you have to ask so many questions. It's not just mom died, okay, let's do a singular heirship affidavit. It's mom died, dad died. Dad had 6 prior marriages and 14 prior children, of which 8 of those have passed away. And I mean, it just gets difficult on down the line so often along the way. And you got to tell the client, sometimes it's cheaper just to pass the deal and move on or try to find another mechanism in order to buy the property. In other words, buy a certain interest in the property, maybe do a partition versus trying to track down, 30 people to execute a deed that you can't find half of them.
What's y'all's record of number of heirs that y'all have worked with?
Alan, I had a lady, this has been years ago, over in Fort Worth, and it was on the east side of 35. And guys, here in Dallas and Fort Worth, we have 35E and we have 35W. And as you go south of downtown in both cases, the neighborhoods east and west are kind of the same, it seems like. Don't know how that happened. But the east side of 35, whether it's in Dallas or Fort Worth, was always the hood. Now that has changed finally over the last 20 years or so. But I mean, those were the bad parts of town. And I had some lady who had a lot at that time that might have been worth $8,000 or $10,000 at most. And I stopped at 29 heirs. I just went, yeah, we're done. You know, the sheer cost of just doing the heirship affidavits was so much more than the cost of the lot itself. So I've only had 29, Alan.
My record's 18. I had one that was up near 30 or so, but the underwriter finally said, no, y'all go to court.
Yep. Sometimes that's the easiest way to do it. I just turn them over to litigation and let the probate court deal with it real quick, or a partition scenario. It just makes our life so much easier.
Yeah.
But they just don't get it, guys. You know, and they don't understand.
I'll have
and
to
you've
pull up
got
my
to
Excel
go through
spreadsheet. Yeah, as I'd say, I'm pretty sure mine was in the 30s. And we were dealing with a great grandparent who had deceased back in the 50s. And it was part of an assemblage that a nonprofit was putting together in downtown Atlanta. And it could not be solved. So again, to y'all's point, we found like a 2% interest from some of the heirs that lived in Chicago, and they bought it. And then of course, partition action to try and, capture the rest of it.
And you know
Uh,
what?
but
Oftentimes that works because no one cares if you can do anything of that nature. But, it's been interesting to watch a few things. Sometimes it teaches you a little bit about your own mortality. As you're getting a little bit older, I had to do an heirship affidavit, and the oldest one I've done was 102 years old for a very nice lady that passed away a few months back. And I got a chance to do one of a soldier who died in 1917. And of course, trying to bring that current, oh my goodness.
It's when you have your escrow officer say, well, the kids, and when they say the kids, they're talking about an 85-year-old person.
Yes. Well, Alan,
Yeah,
as we're getting older, they may start calling us the kids too, okay?
Yeah. Yeah.
Although I'm not
y'all were
getting
talking
older,
about,
okay, guys?
I would say you're talking about airship affidavit. So Georgia, we have published title standards that tell us what to do, and I think we have like 13 permutations when dealing with decedents' estates. And for us, airship, we still have to go to court. You don't have to probate, but you have to get a no probate order from the court if death is within 3 years. So you can use airship affidavits, but you still have to file probate for the purpose of getting the court to say that probate's not necessary. After 3 years, then you're just able to rely on airship affidavits. And then, of course, it depends on whether the will, assuming there is one, was probate in common form or solemn form. And it depends on whether the executor or the administrator has had their letters issued for less than 6 months or greater than 6 months, right? So there's just a lot of, it's like a little pinball machine, depending on exactly where you end up is determined by, the exact fact pattern that you're dealing with.
Well, solves that. I'm not going to do any probate work in, Georgia.
Well, I don't do probate work at all. I mean, we have multiple probate attorneys. As soon as probate shows up, I'm like, do you have a probate attorney? They're like, no. All right, go call so-and-so.
Yeah.
Because my thing is get me letters. And if you don't have letters, right, and of course, if they die within 3 years, and of course, in this market, the answer is almost always yes. Just when you have letters, come talk to me. And what I hate here, and of course, it was the same way in Alabama, like with, the metro counties, is the courts are not only are they not helpful, they will actively deter you from trying to handle probate yourself. And so I think I have 4 files right now where there's no probate attorney. And the ones in like DeKalb County, Metro, nightmare. Like the court won't return your phone calls. We're not a party to the transaction. They don't provide any of their records online. You have to physically go there if you want it. And of course, because of COVID, you have to make an appointment. Otherwise, they won't meet with you. Whereas the more country counties, all their records are online. They're super helpful, super nice, and they will actively assist the petition and tell them, hey, don't forget to come in and do your oaths and things like that. Whereas the metro counties are, you don't have a lawyer, don't talk to me. right? I mean, it's a night and day difference on how the courts either will assist or deter in a probate action.
So not to turn this into a networking event, but need to put your email in there. I've got a Georgia referral I need to send to you.
Absolutely.
And then if anyone has California rap attorney, let me know.
Call me, Alan.
Who was that?
That was
Scott.
Scott.
California?
Well, we can close the deal out there, yes.
Okay. All right. Good deal.
If you're just joining us, folks, this is the Creative Finance Collective. We're talking about anything that we decide we want to talk about because we can. Well, what we're really talking about is things relating to creative finance and creative financing. So if you have a question, make sure to post it in the chat. We're here to answer any questions that you have. We've got lawyers from a variety of different states here: Arizona, Georgia, Texas. So go ahead and post that in the chat. I wanted to get your guys' take on this, maybe take a temperature from around the country and kind of see what you're feeling, but a kind of a new trending. This isn't new to us. If you're in creative finance, you know what the market looks like out there. You know that rates are expensive and investors or buyers love this idea of being able to take somebody else's loan, buy the property subject to that existing loan. That's essentially what creative financing is, in a variety of different forms to it. But we kind of know what the economic environment is, but there's kind of a new trending hashtag out there. They're calling it the affordability crisis. And I just saw this yesterday. So if there were ever kind of a question as to what this is going to look like going into 2024, this is a quote from Doug Duncan, the chief economist for Fannie Mae. We expect a higher mortgage rate environment to continue to dampen housing activity and further complicate housing affordability into 2024. That's the end of the quote. Now, that's probably not a shocker to any of us.
Thank
But
you, Mr. Biden, right?
If anybody's in the know when it comes to residential housing, you might think it's the chief economist for Fannie Mae. I don't know him from Adam, but he holds a high position. Their reading of the tea leaves is that this affordability issue, high rates coupled with high prices, is not going to go away, at least in the short term. We're going to be dealing with this in 2024. There's just about no doubt about that. Have you seen, we kind of take this temperature here and there, but you guys over in Texas and in Georgia, have you seen an increase in subject to transactions? I still feel like the cat's still not out of the bag on subject to transactions. Like there's still, investors, sophisticated investors, and know about it, but I don't know that it's reached down, to the dinner room, the dinner table at night for, the kind of the average Joe to know about.
Yeah, I agree 100%. It's still kind of mystic. We have a fella in Austin, a mortgage guy, and he, doesn't have any work. So he's gotten creative, quote unquote, and he is out marketing to just the average Joe real estate agents. Basically, I think he's looking at 90 days on market, prices above 500,000, and marketing to these agents, teaching them about this mortgage wrap thing. And then he has his RMLO work that he's going to be charging or what have you, and then ship those over to us to close. So the people who are going to his events don't know anything. So I agree. It's still a mystical thing out there that just the investors know.
And Alan, just like your fella doing that, I got a call today from a major Keller Williams broker who's got a huge office in Rockwall, huge office in Plano, going, we need you to come in and help the agents understand how to do this the right way on either with a owner to owner type transaction, owner to investor, whatever it might be, so that they protect themselves, because agents are never taught the creative side of this industry. In fact, they're taught usually the exact opposite, that you can't do it for whatever reason it might be that's out there. And you get the blind leading the blind. It's bad enough in the investor community that everybody takes some quick course out there right now. Doesn't matter what the course is, who the guru is. They all get involved quickly and they think they become overnight experts and they really have no clue what they're doing. And that's where, the Scotts, the Allens, and all you guys step in to try to help them put these deals together more appropriately, if we can do it. But, investors are normally the last people homeowners call in the event that they need to sell their home. They just don't call the investor side. They call the realtors first. And when they realize they can't sell the home for what reason it might be, and the realtors just can't help them, then the investors get the phone calls typically next along the way. And your mortgage guy going out and trying to educate. And of course, I look at this and always wonder, how much does this guy really know about the creative finance world and all the rules and regulations you've got to follow? Maybe this guy is up to speed on it. He's really good about it. But I find so many of these people who teach, this business, they're not. They miss all the little nuances that are so important to know. But I do think it is so important for those who are very, very knowledgeable of our industry to get out in front of the agents in order to help them better understand. Because remember, guys, in the real estate world, a realtor's job is to market the property and marry a buyer and seller together and then get the hell out of the way. And unfortunately, they all fall over themselves doing everything else in the middle they shouldn't be doing. They do. And what they don't understand, of course, is that unlike a traditional real estate transaction where there's a mortgage company, they're going to do a home inspection, there's a title company, there's this, there's that, and all these various steps in the creative finance world, most of those go away. But they don't understand that the seller becomes the lender, becomes the underwriter, and they want to help this seller do all this, but they're not licensed to cover it. And if they start meddling in those kind of things, they start to step in the middle of things they shouldn't step in and put their license at risk sometimes. And so I like to try to educate the realtors out there to get them knowledgeable of who they need to be incorporating into their transaction, give them the resources of what they need to reach. So when that time does arise that they find that seller or that buyer that needs to do a transaction like this, they know who to reach out to, who can then help put that deal together for them properly. But it is coming. It is getting more prevalent. The marketplace isn't going to change. It's going to tighten up more. People are going to have more problems. They already are having more problems. I'm seeing more foreclosures every month. Even in my own world, on my own pool of mortgages that we own and control, I had 5 properties posted for foreclosure this month for the first time in 12 years. I usually have 0. I average about 0.25%, a year of foreclosures. And I had 5 this month. And I look at that and I go, what's going on? No, is that just an anomaly? Is it signs of the time? I don't know. But I think you're seeing situations arise out there because, as you said in the marketplace, as construction slows down in the housing industry because rates are too high, people can't afford the mortgage payment, construction's going to slow down. As construction slows down, people get laid off of work. And a lot of those buyers, people who are laid off, are the buyers who buy with owner financing. Or as they get laid off, they've already bought a home with owner financing and now they can't afford it in some format. And I think there's going to be a trickle-down effect along the way that because of those things are happening, where I think there's going to be a lot more people who can no longer afford their homes. I've seen several deals just in the last 90 days where homes that were built in 2021, people bought these brand new houses, and all of a sudden, a year and a half later or so, now they can't afford the property. What happened? Why? And what's that change that's ongoing out there? But you're beginning to see the signs of the shifts in the marketplace because of high interest rates. And then when you get that downturn in the housing business, your home builders go out of business, your construction guys go out of business, your mortgage guys go out of business, realtors go out of business. And if they're getting in a pickle with their mortgage payment, what do? And if they just bought this house a year or two ago, they have zero equity and the ability to resell it without taking a loss, which they can't do. They're stuck. And the only answer they have is to learn the creative side of our industry to help them get through this.
Well, and what is the one barrier? Not just the one, but I would think from the seller's perspective, the biggest barrier to getting your head around a creative finance deal is the credit risk you're taking that's out there. But if you're a distressed seller and foreclosure's on the horizon, the credit risk or your credit exposure is kind of baked in at that point, right? At that point, I could see the calculus being, well, I might as well. It's a better risk to take it on a subject to deal as a seller than the known foreclosure that is gonna hit my credit.
Andy, I'll make a comment. Years ago, this is one of those situations. It's like, where in the world is my camera, to record this when I need it? And I'm going through this a closing with a lady who's in a pre-foreclosure scenario. And when we do this, we go through the entire closing package, the disclosures and all the things that we do to make sure that they understand what's going on, the risk factors, yada, yada. And this lady just stopped me. She says, stop. I get it. I can either do this today or I get foreclosed on in 5 days next Tuesday. And she said, even though I realize that this may not work in a year from now, I might be back in the same scenario. It's not Tuesday. So here in Texas, guys, we foreclose the first Tuesday of every month. Mm-hmm. And this lady just laid it out so clear. She got it. I mean, she was a musician. She had no options. It was going to foreclosure. It was done. Either stop the foreclosure now. It might happen later, a year or two or three from now, but it's not now. And I think when that light bulb goes off and they get it, they realize most of the time the creative finance solutions are the best solutions in their situation.
I want to go on record and say that a real estate agent representing someone in the sale of their house that doesn't know about mortgage wraps is committing malpractice.
And by the way, I don't disagree with that. In fact, I even heard of a lawsuit years ago in California where the agent didn't present a seller finance option to the seller.
Yeah, when I call up the agent and say, hey, like to see if your client would accept a seller finance offer, they say no, and then I tell them it's possible to do mortgage wrap. I guarantee you they don't tell their client.
Guys, I hate to keep sharing stories, but I think I've been doing this longer than all of you guys combined out there. I clearly remember back in the real estate crash days, this is probably the beginning of 2010. So if y'all don't know, I'm a lawyer and title guy, but I'm also an investor here in the Texas marketplace. And I'm talking to this agent about a house that is going to foreclose in literally, I think it's probably at this time, we may have had 10 days before foreclosure. And the house had been listed for months and months and months and hadn't sold. And we go in and make the offer. And the agent goes, no, I can't do that. And because of various factors, I couldn't offer the agent a 3% commission. The numbers there was too much money that was coming out of pocket. But I was going to offer the agent, a 1 or 1.5% commission, I believe at the time. And the agent's comment was, I can't do that. I'm going to lose money. And I'm looking at this guy, I'm going, when the house gets foreclosed, you ain't making squat. You're going to lose everything. At least I'm offering you to make a little bit and to save the seller's credit and save the house from foreclosure. Well, guess what happened 10 days later? House got foreclosed on. Agent didn't get anything. Seller got screwed. And Alan, in that case, that's the kind of an agent that should have been sued for malpractice in that scenario.
Yeah.
I agree with that. And I think you see a lot of that. I think a lot of that, though, is just, unfortunately, it's ignorance of the marketplace. Um, I happen to be an RMLO as well. So of course, when you go take your RMLO classes, they talk about that much about creative finance. It might be a blurb on the radar screen, and that's it. And the people who are getting into the mortgage world learn nothing about this side of the industry. And I think that they should incorporate that. And although I've never gone through the real estate classes before, I'm pretty certain that they don't teach you a whole lot about owner financing in there. It might be another blurb. That's about it. And I think these companies that provide this education out there for realtors, RMLOs, et cetera, they need to find a better way to incorporate that into their programs a little bit, because I think this is something that's here to stay. And at least for the next 5 years or so, we're going to be in this scenario where we have high interest rates and whatnot. And a lot of sellers are going to need a lot of help.
Well, there was a period of time, doesn't go back that far, where if you wanted to be a real estate agent, you were doing short sales. There was no other type of work. And early on, I know Sean worked with a ton of them, so he could give you all kinds of stories. But early on, they didn't know what they were doing. They didn't know what the banks were going to accept. But the market dictated that if you were going to sell real estate, it basically had to be done as a short sale, because there was no equity in anything and everything else. And it makes me wonder, we're obviously not there yet. And a lot of that has to do with, the Fed raising rates and the speed at which they do it. And this takes time. It makes you wonder, though, if it's coming. At what point is the market essentially going to dictate that realtors, agents, they're going to have to learn this if they want to be agents?
Hey,
Well,
Alan,
let me jump in on this, Andy, because I have created and work with a real estate school here in Arizona to teach a 3-hour legal issues course on creative financing, which is, the majority of which is dedicated to subject to and wrap financing transactions. I have a class coming up here in November, and I've taught for a realtor association up in Northern Arizona back in September. But what's interesting is I always have people come up to me and before the class, these, real estate agents are like, what about the due on sale clause? How are we going to do these transactions with the due on sale clause and this and that? And I said, well, I'll talk about that, and so then I go through my presentation and, I talk about the due on sale clause. I talk about some of the attorney ethics opinions out there. I talk about efficient breach. And then I always ask, I said, well, who here has been through the, downturn in the market? They all raise their hand. I'm like, so you guys should all know about efficient breach, because you were having your clients breach their loan documents to do a short sale. And you didn't seem concerned about it then. But of course now, it's like, oh, due on sale, due on close. It's like, wait a minute. We have this whole era of people breaching their loan documents and real estate agents assisting them to do it. And yet all of a sudden now with the subject to, it's this thing that's so bad, so horrible, so illegal, so, wrong. And it's like, yeah, you'll find out, when you really need that commission, that all of a sudden, oh, efficient breach works, and maybe we should be doing wrap transactions. So I just think it's funny that the same agents that were so active in the short sale eras are now like holier than now, like, oh, we're not gonna be involved in this because it's wrong, you're breaching your loan documents.
Sean, to play devil's advocate on that, though, I think one of the other issues that people are having with the due on sale clause is the fact that in the short sale period, you were only dealing with the seller who was breaching. In the case of creative finance, you actually have a buyer that's engaged in that transaction as well. And so the concern is, all right, you get into this creative finance transaction, and then all of a sudden the lender sends a notice of breach and an acceleration of the debt. And now you have to work something out, not just with the seller who's on the loan, but with the buyer who's sitting there in the house wondering what's going on with my loan. Right. And so I think that's the fear. I mean, I was just speaking with my brother-in-law and sister, because they're looking at moving, and they have a VA loan at like 2.15%. And I was like, you need to at least explore the idea of creative financing, because you have a loan that's incredibly valuable to a buyer, because not only because their VA loans are assumable, right? And so hypothetically, you may not even have to do creative financing, but depending on the scenario, that may be an option as well. But for them, they had a total fear, like what's going to happen in the event that I go and I essentially become a lender, and the VA discovers the situation and calls my loan due, and I had to walk her through exactly what that was going to look like. The amount of education you have to do to a potential seller on that is really important. And I don't know how much you guys have talked about that, and what you really need to have in place there, but it's not a simple thing, and so education's key, I think.
Right, and that's what I talk to the real estate agents about. And in fact, on our website, I offer, assuming I don't have a conflict, I basically say, get in to me and see me before you have a buyer. But I offer like a seller consultation on my website, where a seller is considering creative finance. I offer a little bit of a discount for them to come in and sit down with me, and I can go through, what it might look like. But yeah, you're right, Brian. I mean, it's this boogeyman out there, due on sale clause, and no one really, understands what that looks like. And I know that I've dealt with it in restructured transactions. I've had clients who have just refinanced, sold the property, whatever. And I know Alan and Scott for sure have dealt with it when the due on sale clause, comes out. And there's ways to deal with it. I mean, the lender always sends a notice and that type of thing, but the seller needs to understand that. And then in Arizona, and I talked about this on our podcast this morning, in Arizona, we have anti-deficiency statutes, which basically say, even if that lender calls the loan due, they can never collect against your other assets. The only thing they can do is foreclose against the property. Now, a foreclosure is damaging to your credit, so there's some credit issues there. But at the end of the day, if somebody offered me, say, 5% more than the fair market value of my house, 10% more than the fair market value of my house, I'd take that and run. I wouldn't worry about my credit at that point, especially if I could get, cash out my equity or whatever, and take the extra money and run. Yeah, forget it. My credit's not worth 25,000 or 50,000 at this point, in my view.
Well, and to your earlier point, if you were through the short sale process, complex transactions should not be new to you as a realtor. How many of them that we worked with got the deal, but then had to have us review it as attorneys because they couldn't give legal advice? We would review it. We'd review the affidavits that were signed, advise the person facing the short sale about what the application of the anti-deficiency statute, whether it did apply or whether it didn't. There was work going into the negotiation of the short sale letter itself as to whether it was going to release them from liability or not. There was all kinds of exposure. But going back to Scott's earlier comment, the job back then for these agents was to introduce the parties, not to flesh through every one of these legal problems and have to give legal advice and answers to them. They're not going to be able to. But, and adding on to this, you guys were mentioning it, and we've talked about it before. At some point, we're going to start seeing more and more people see this loan as an asset and marketing it that way. And there's lots of buyers willing to pay a premium for that asset. In fact, I was just online a couple days ago. Somebody that wasn't even in the creative finance space or whatever else, somebody with a big following posted, had a whole post about your 2% mortgage is an asset. You need to start seeing it that way. And more people are going to do that. But at some point, I think the market's going to dictate agents have to get on board with this, because I think it's going to get harder and harder to do deals without it.
They got to figure out a good way to advertise it, right? Because, this is not a one size fits all type issue. For the person that's in pre-foreclosure, it's a no-brainer. You just need to offload this property, and if you can do it, via creative financing, that's sort of an ideal situation in a bad scenario. But for people, you know, and I bring it up again just because it was so recent, but like with my sister and brother-in-law, they have a recently remodeled house. They can afford it, but they just happen to have this really great loan on their home, and they're looking to relocate across the country. And creative finance doesn't won't make sense unless they can advertise it to a broader audience. But I don't know that there's really a marketplace for that right now. At least none that I'm aware of. And you know, real estate investors don't see a ton of value in it unless the house is just right. You know, for a rental or whatever. But if it's not distressed, they can't make money on a flip. And so it's, yeah, I feel like until this gets broader adoption within the real estate, you know, with agents, and find a marketplace to be able to make that part of the listing when it gets listed on the MLS, I feel like it's going to remain sort of a niche type
Well, you know,
thing.
years ago, guys,
I would.
years ago down in Austin, in Allen's neck of the woods, some company created the short sale company that eventually had 40,000 realtors as subscribers to it, which was the short sale training class. And Allen, I don't remember the name of the company anymore. It was too long ago. But no, they were huge. And of course, they would bring on to their podcasts and whatnot the chairman of the board of Chase, of Bank of America, on down the line, who were pushing all of this. And of course, all of this was government backed in some format at the end of the day to get people through all of that. And today what we have in lieu of that, we have various entities out there that push the creative finance world a little bit. And y'all's neck of the wood, Pace Morby does a lot of this out there to get at least the investors more knowledgeable in that arena. But no one's really pushing that into the realtor arena. We tried that here in Texas, and sometimes you get a lot of pushback still from the brokers and whatnot because of liability issues and because they just don't understand it. But I do think you're right that you've got, until it becomes more mainstream into the realtor marketplace, it's never really going to take off in the way that it should probably.
Well, Brian, to your point, I will tell you that where I've seen people list or sellers list on the MLS in the comments that the seller will consider, wrap financing of their, 2 whatever loan. My understanding is when that's listed, like there's a frenzy, like people come out of the woodwork wanting to do that transaction. And I know investor clients who are not like, it's not their day job, let's put it that way. And they have assets, they have cash. Investor clients who are cashing, these homeowners out to basically take over the mortgage, to rent the property, to, take advantage of the depreciation, the mortgage interest deduction. And they're, basically doing pretty solid deals on this stuff as far as the seller's perspective. And all you have to do is just put it in there, like seller will consider wrap financing, on their whatever. So it's something that it's kind of this underground thing, but if you get it on the MLS, it does result in kind of a frenzy of activity.
In my view, though, that's only half the problem. That's only half the solution, right? Because because for me, let's say I'm not in pre-foreclosure, right? So I'm doing this purely because I want to add value to the home that I'm attempting to sell. That's great, but now I'm not going to qualify potentially for another mortgage for wherever I'm moving, right? So the adoption part of it is what's so important, because if I'm going to go and have my loan wrapped, I need to go find a home wherever I'm moving where I can go get another wrap transaction as a buyer instead of a seller.
Yeah.
So I don't have to go worry about qualifying for another loan when my debt to income ratio is all screwed up.
Well, Brian, let me make
that's Correct.
Yeah, let me make a comment about that though. So first off, the great majority of people that you run across in these scenarios already have credit issues, meaning it's going to be 1, 2, 3 years before they can buy a home anyway in most cases, but not always, as you noted. I just did a deal down in San Antonio for a client who was moving to Indiana. House wasn't moving. They were looking for any mechanism because they'd already bought house number 2 in Indiana and they needed to get out. And so I just simply made the suggestion to the agent how to do this. And bang, bang, in about a week, they had a buyer and we closed it just a few days ago. But, for the most part, if you can give the investor minimum 6, but probably 12 months in order to, have a consistent pay history, then mortgage companies are going to treat this like a rental property. Now, from there, it's all about the debt to income ratio, as you indicated, because they're going to take 25% of the monthly payment against the DTI out there. But after 12 months and a good pay history, many of these mortgage companies just discount the loan to zero. And underwriters do things differently based upon who you're talking to along the way. But rarely do you find sellers who are talking about buying another house next week. You do run across it, but that's more of an anomaly than what is the norm typically in the industry right now, from at least what I see.
So if we're using my scenario then, where again, I can afford my house, I'm trying to add value.
Yeah.
Then if I'm okay with renting for a year in wherever I'm going, then that may be okay as long as whoever acquired, whether it's an investor or otherwise, as long as they have 12 months of consistent payments, then my debt to income ratio issue may not be one.
Yeah.
At that point.
But if you sold your house and you got a $50,000 down payment and your positive cash flow, it might be $1,500 a month, $1,800 a month based upon your scenario you described. When you go to that new mortgage company and now you have more cash in the bank to put a larger down payment down, maybe that now you have all this additional positive cash flow, sometimes from a credit perspective, that makes you look better also. I think that it just depends on who the underwriter is and who the presentation is I think you're going to get very different answers from their very different underwriters that are out there.
Yeah.
There's a trick you can do. I'm not suggesting people do this. I'm glad this isn't being recorded. But if you have
it is being recorded, just so you know. It's being recorded.
If you have a cash offer on your house, then that DTI issue goes away. And so maybe hypothetically speaking, that mortgage guy that might be touting these things out to real estate agents, that's what he's suggesting. If you want to get into your new house, we're going to have a cash offer. He's using one of those orchard companies or what have you that will give you a cash offer.
Yeah.
And then you get to go and qualify for your new mortgage and then close however you're closing.
Close it as a wrap, but have the cash offer for purposes of the new loan. Yeah, that
hypothetically.
Did anybody hear that?
No, nobody heard that.
Okay.
One thing that would be helpful is, you mentioned Fannie at the head of it. I mean, it's the fact that all of these things are wrapped up in basically mortgage-backed securities that make them unable to basically be renegotiated. Because I know in the commercial space, you have a lot more flexibility, right? And you're seeing some really interesting looking wraps where a really strong sort of mez-ish lender gets involved, but they don't want to actually be mezz debt, right? So they force the borrower to go into a new SPE, transfer into there, and then they wrap it back to the first lender and they negotiate better terms. And then they capture the screen and obviously they eat some of the equity from the borrower, right, to make the deal work. But you can't do anything like that in residential because it's all so cookie cutter, right? And so, I don't know if Fannie would come up with a way, or the other government sponsored entities would come up with a way to allow basically the assumptions like they do with the VAs, or allow basically a swap between your borrowers, or just more creativity again that you see in these, more interesting commercial deals that are just simply not feasible in residential. Instead, they're doing these wonderful grants. Have y'all seen grants in the normal retail closings where you have a whole second loan package. And it's a grant if you don't sell your home within 5 years, but it's that whole down payment assistant thing that Fannie came out with, and now Zillow's involved in it. So, the lender tells you, oh, no, it's just a grant. Great. So why are we creating a second borrower CD, and why do I have another 80-page loan packet, queued up in
Yep.
my printer if it's not a loan? Oh, well, it is a loan if they sell it. So instead of allowing the lenders to have flexibility in renegotiating the terms of the loan, they're just foisting another loan product on top of your borrowers to try and solve the affordability crisis. And I just don't know if that's a very wise move.
But nowadays you're seeing these DPA loans. It used to be, after 12 months, they were forgiven. Then it was after 5 years, they were forgiven. Then it was after maybe 10 years, so long as they still haven't sold the house, it's forgiven. But today, what I'm seeing more so of is where the loans are for the life of the loan. It might be zero interest, zero payments, but now instead of being a grant, as you're talking about, it is a loan that has to be paid in some format. And so,
So a question on that, on these grants, when you sell that property via a wrap, and then that time period comes up to 3 years or what have you, are they checking ownership on those?
well, the problem is, I think, Alan, is they can check ownership. So, just for the group here, in fact, I was talking to a gentleman today on that exact same scenario that had a grant that it expires in 13 months. And he's asking, how do I buy it? Do I buy it with a lease option? And I said, well, that's a way of doing it. You could buy it with a contract for deed, since it's not going to be an owner-occupied property here in Texas. I said, or maybe call the mortgage company. Ask them if you can put the property into a financial planning trust, and if that in any way violates the grant provisions for forgiveness of that loan. And the answer was, if they say, no, it's okay, great, let's put it into a land trust and we'll convey the ownership over. And we're just not going to record that conveyance in the land trust until that DPA loan is forgiven. But if the answer is it does, then okay, then you have two other options to consider, and you let the investor make the call what's best for them with either one of them.
We've closed two with those forgivable loans in place, and the investor knows, all right, well, if I get caught, they were smaller, 7,000, 8,000, what have you.
Mm-hmm.
And so I'm interested to see what happens when it comes time to forgive those. Are they going to do a title check and see if their borrower is still the owner or not? So I've got I think about 8 months to wait, and I can update y'all.
Yeah. But I just think one of the things, Alan, is when you're dealing with that DPA, if it is a forgivable type scenario, you want to try to keep that in place if possible, and do it in a way that would be beneficial to both the seller and or the buyer. Because remember, these buyers can always default along the way. Things do happen, and the seller gets it back, and we don't want the seller to be harmed and that not to be forgiven as originally agreed upon. I just think it's a matter of looking at the deal overall and helping them navigate it. And they have to pick and choose what works. But you got to find out, where does the lender stand? And I don't know that answer, because I think if you just arbitrarily do a wrap and move on, could they check on it? They could. And I can't remember if I've had that happen before or not. I've slept a few times since then. But something in the back of my mind says I've had that happen once, maybe years ago. And it was an issue, at least, that they had to deal with.
This is a dangerous question to ask lawyers, I think. But have they addressed how this forgiven, the grant that's forgiven or a loan, whether it's a grant or a loan, how that's going to be taxed? Because forgiven debt, we ran into this with short sales, forgiven debt, that's, forgiveness of debt income. I think they ran into this also with the PPP grants. It's like, okay, well, we're going to give this, but we got to pay a tax on that? It's like, oh, we didn't think about that when we passed it. We better address it after the fact. But I'm curious, do we even know or what the thinking is on that? Or Anybody?
I
heard?
don't know that answer, but I don't believe I've ever seen anybody get taxed when the DPA loan is forgiven.
Okay.
I think that since that money went to the seller, it didn't go to them per se. It was used for the purchase of the property, but they found a mechanism or a way to get around that from a taxability perspective.
I see.
But don't hold me to that answer, just like we won't hold Alan to his magic trick.
Well, hey guys, it's just about 3:00. You guys have been kind and offering your time. We really appreciate it. And if you're watching this Creative Finance Collective, make sure to join us. We're getting together now on Tuesdays to go over creative finance and answer any questions. So appreciate everybody's time. Let's do it again.
We'll see you guys soon.
Yeah.
Thank you.
All right, we'll talk to
All
you.
right, thank you, everyone.
Thanks, guys.